Have you ever been called to jury duty? Most of us expect boredom, but for one woman, it ended with a prison sentence. This is the story of A.G. versus Dallas, a legal case that teaches us how dangerous curiosity can be when justice is on the line. Let's unpack the moment the courtroom turned on its own. Meet Theodora Dallas, a university lecturer, sharp, composed, used to guiding the room with questions. But today, she sits in silence, one of 12 jurors, and soon, a single choice will send the entire case spiraling out of control.
Let me be clear. You are to decide this case based only on what you hear and see in this room. Nothing else.
Jurors are told, no outside research. It's the golden rule of any trial. And yet, that night, alone at home.
I can't believe what I just found out. He is a criminal.
She searched. Not out of malice, not to sabotage. Just a quiet doubt, steady, persistent, whispering that something wasn't right. She typed it out, defendant plus criminal charges, just a few words, and suddenly she knew something the court had deliberately kept from her. And she said it, out loud, right there in the jury room. Just one comment.
Look, I know we were told not to, but I looked him up. He has prior criminal charges, serious ones. I just couldn't ignore it.
And everything fell apart. The trial collapsed, mistrial declared, the victim left in limbo, the system shaken. The court called it contamination.
This act threatens the very trust we place in juries. I find you guilty of contempt.
Dallas, she called it context. So here's the legal question. Can a juror, someone trying to find the truth, be punished for seeking more information? When does civic duty become civil disobedience? And when does curiosity become a crime? The answer lies in law, specifically the Contempt of Court Act 1981. It states that jurors must decide only on what they hear in court, no personal research, no outside facts. Because trials aren't about what's true, they're about what's proven, under rules designed to protect everyone involved. Theodora Dallas wasn't reckless. She was thoughtful, educated, but she'd been warned, and she broke the rule. Dallas was sentenced to 6 months in prison.
You will be sentenced to 6 months in prison.
No outburst, no protest, just the quiet weight of the verdict settling in. The headlines were brutal. Juror jailed, contempt of court. She wasn't the defendant, but that day, she was the one judged. This case wasn't about proving guilt or innocence. It was about a juror's duty. The legal system relies on boundaries. Evidence must come from court, not curiosity. A.G. versus Dallas draws a sharp line between seeking knowledge and undermining justice. The law doesn't punish curiosity itself. It punishes the disruption of fair process. Because justice isn't built on Google searches. It's built on structure, procedure, and trust in the system. Let's summarize what we have learnt today. FIRAC-style. The facts? Theodora Dallas was a juror who looked up the defendant online and shared what she found with the rest of the jury. The trial collapsed. The issue? Whether a juror can be punished for doing their own research and contaminating the trial. The rule? Under the Contempt of Court Act 1981, jurors must only rely on what's said in court. No outside info, no exceptions. The application? Dallas ignored a direct instruction from the judge, searched online, and brought in information the jury wasn't supposed to hear. That disrupted the fairness of the trial. And the conclusion? She was found guilty of contempt and sentenced to 6 months in prison, a real sentence for a real breach of duty. A.G. versus Dallas is a powerful reminder. In law, even good intentions can cross the line. And when they do, the justice system has to respond. Thanks for tuning in. If you found this breakdown thought-provoking, hit subscribe and share it forward.